This is Akashvani. In the program Spotlight, now we bring a discussion on Supreme Court verdict on abrogation of Article 370. The participants are Mukesh Ranjan, senior journalist and internal security expert, and Bala Nagendran D, Akashvani correspondent.
When Parliament enacted the law to abrogate Article 370 on 5th August 2019, the issue had been the bone of contention. Today, the Apex Court, with 5-0 verdict, which means unanimously, proclaimed that the abrogation of Article 370 is valid and proposed various suggestions to bring in normalcy to the lives of the people. To talk more about the verdict as well as background and further developments, we have with us an expert with full of experience, Mr. Mukesh Ranjan, political analyst and internal security expert. Sir, welcome.
Thank you.
Sir, I would like to start from asking you the highlights. Could you briefly highlight what happened today in the verdict of Supreme Court? What are the highlights of the verdict?
Today's verdict, first that the verdict endorsed the government decision to abrogate 370. The major highlights of the judgment today are 7 in total. So the first thing is this, that court has said that Jammu and Kashmir did not retain sovereignty after accession to India. Then secondly, it said that Article 370 was a temporary insertion in the Constitution of India. The third one is that no malafide was there on the part of the government in the exercise of its power under Article 370, bracket 3, in abrogating Article 370. Then fourth is that reorganization of Ladakh as an union territory has also been upheld by the court. Court said that the purpose of Article 370 was to slowly bring Jammu and Kashmir at par with other Indian states. Then the court said that Article 370 is an example of asymmetric federalism, where it means that it is part of the federal structure of India but remained asymmetric so far as 370 was in operation. The seventh one was the judges said that government should go for setting up of a Truth and Reconciliation Commission to look into violations of human rights by both state and non-state actors.
The seventh highlight about reparative approach. I would like to ask you, what do we mean by the Constitution of Impartial Reconciliation Committee and reparative approach, and why that there is a specificity of 1980 and post-1980?
In this context, the court said that the armies mean to fight enemies and not to be deployed for controlling law and order situation. But the situation evolved in such a way in Jammu and Kashmir, particularly in late 80s and early 90s, that the government of India was forced to deploy army there and control the situation. In the process, the human rights violations took place from both sides, in a sense that the army also dealt with the situation with a strong approach. Similarly, as we all know that the Pakistan pushed terrorists to our territory, so lot of human rights violation took place due to that also. After that, in early 90s, what had happened that majority of Hindus, Kashmiri Pandits, were pushed out of valley and they became kind of a refugee in their own country. So lot of atrocities took place because of this also. So court wants that government should consider setting up a Truth and Reconciliation Commission to find out what all happened and how this can be reconciled and things would be brought to normal.
Sir, in addition to that question, the court has also highlighted that such reconciliation committee shouldn't act as a criminal court. So what the court trying to say?
Court is basically avoiding to award punishments. Basically, focus is more on reconciliation and finding truth. So once the truth is found, population is reconciled, things can be improved without meting out punishments. If you do the other way around, it will create another problem in the society.
So it is equal to say that forgiving the wounds of the past.
Yes,
Actually, then it brings me to the next question about the electoral process. The court has mentioned September 30, 2024. Before that, the election should be conducted, and they have directed the ECI to take the electoral process so that it can be conducted within the time limit given. So what is your take on this? How significant is this going to be in bringing positivism into the youths and the aspiring people of Jammu and Kashmir, especially when you have this democratic process put in place?
We are a democratic country. Aspirations of people are expressed by their representatives. Now, what has happened that people of Jammu and Kashmir do not have their own government, their own representatives ruling them. Now, for a particular situation or a special situation, the president rule was imposed earlier, and then when it was reorganized into two union territories, J&K and Ladakh, so the two UTs were put under lieutenant governors. Now, Jammu and Kashmir has been provided with a legislative assembly. Now, this UT status to Jammu and Kashmir is temporary as far as the law is concerned. So, once election is held, the administration of the Jammu and Kashmir will become participatory. Now, the integration of Jammu and Kashmir legally has been complete now today after this judgment. So now, since they are at par with other states and union territories of the country, since J&K has its own legislative assembly, but natural that the people of Jammu and Kashmir should have their own representative ruling them and fulfill their aspirations. Because a lot of schemes and a lot of development initiatives have been taken by the center, but after saying that, it requires to have a representative government in Srinagar so that they can approach their representatives, get their jobs done as it happens in other states. So since integration is complete, people deserve to have its own government there, and for that the court has given a timeline that election should be held by 30th September next year.
So talking about the constitutional aspects, I would like to know from you for the benefit of the listeners. Generally, we speak about amendment based on Article 368, where the amendment procedures have been mentioned for the ordinary bills. But the court has said that amending by means of Article 367 is not permissible. What is it trying to say?
It is very clear in a sense that 368 provides the provision for amending the constitution. That's a fact. Now, 367 was inserted to original 370. It was Constituent Assembly. So now concurrence of Constituent Assembly was mandatory for abrogating 370. But it was later on was amended and 367 was inserted to replace Constituent Assembly by Legislative Assembly. So now the court says Constituent Assembly doesn't exist, and this was malified to replace Constituent Assembly with Legislative Assembly. So court said that since Constituent Assembly doesn't exist, the government of the day has the right to give its concurrence. So on the basis of that, court has validated the union government's decision to abrogate 370.
Sir, the region of Jammu and Kashmir happens to be one of the tense zones. It is militarily dense as well as a challenging zone for India's internal security and border management. So, with this verdict, what do you think that the future is going to be?
Now, with this verdict and complete integration of Jammu and Kashmir with India and total control of the national government, it is going to be very good for the people of Jammu and Kashmir, because on two fronts, on the security and development indices, on both counts, Jammu and Kashmir will become a safer, a prosperous territory to live in. First thing is this. Internationally also, the issue has several times been internationalized with hostile neighbor Pakistan. It always remained a disputed territory. So now with this verdict, the entire process of complete integration of Jammu and Kashmir into Indian Union is now settled. So now the people of Kashmir will have a kind of a life which could be as good as in other parts of the country. Like I'll tell you, since 2019, August 5th, there has been a marked improvement in Jammu and Kashmir, both in security wise and in terms of development. Like I'll tell you, the government figure says that there is around 32% decline in the act of terrorism compared with the last 10 months preceding August 5, 2019. Similarly, death of security forces have also declined and fallen by 52%. Similarly, death of citizens have also come down substantially. On the development side, interestingly, private investment used to be very meager. Earlier, it was overall rupees 14,000 crore, but after August 2019, in last 4 years, there are rupees 81,122 crore of investment proposals are there. A total of 25,000 crore work projects are under execution, and proposal to the tune of over 80,000 crore are under process. So lot of things are changing. You have a very substantive jump and surge in tourist footfall in Jammu and Kashmir. Jammu and Kashmir is considered to be heaven on earth, and people want to go there, but given the security scenario we had, say about 5-6 years or 10 years before, people started avoiding visiting Jammu and Kashmir. So gradually things are becoming normal. With this verdict, we'll take a quantum jump and we'll see a brighter future for Jammu and Kashmir.
With that being said, sir, I would like to ask you two questions. One is before 5th August 2019 and another one is post 5th August 2019. First, let's talk about the backgrounder. What motivated, what led to the decision of the Parliament on 5th August 2019, which led to this landmark verdict of Supreme Court today?
For this, we have to go back to 1948-49, just after independence and accession of Jammu and Kashmir into Indian Union. At that point in time, a section of political spectrum of that time was not in favor of giving any special status to Jammu and Kashmir. But given the fact and the situation, then Government of India decided to accord a special status to Jammu and Kashmir. Now, what happened? That the same spectrum of Indian polity at that point in time formed a political party called Bharatiya Jana Sangh. So, Bharatiya Jana Sangh came into being post 1951. Since then, Bharatiya Jana Sangh had in its core to demand that Article 370 should be abrogated. So that remained part of its demand and its core agenda. That Bharatiya Jana Sangh later on in 1980 became Bharatiya Janata Party. Now, Bharatiya Janata Party's core agenda was obviously again continued to be abrogation of 370, and they used to fight elections on the basis of their stated position on Jammu and Kashmir. So now once the party came into power with full majority, they basically fulfilled their commitment and their promise to the nation that we will integrate Jammu and Kashmir completely to the Union of India, and they just required majority in both the houses of parliament. When they achieved that majority in both houses of parliament, they brought out a legislation and amendment bill, and they did it. Once they did it, it went for judicial scrutiny. Basically, it passed the judicial scrutiny, and now today process has been completed and Jammu and Kashmir has been completely integrated with the Union of India. Now, here there is one point that with this Article 370, there was a provision called 35A. And 35A given it a special status in terms of government jobs and also property right. So, property right and government jobs were reserved under 35A. The domicile used to be determined, and they defined domicile in a different way. Like, I'll tell you, a girl from Jammu and Kashmir, if married to a non-Kashmiri, she forfeited the right to have property in Jammu and Kashmir. So such kind of discriminations were there. Even lot of reservation provisions provided to rest of the people of rest of the country were not applicable to Jammu and Kashmir. So likewise, several discriminatory provisions were there because of Article 370. Now with this, everything has been settled.
Sir, thank you so much.
Thank you.
You were listening to a discussion on Supreme Court verdict on abrogation of Article 370. The participants were Mukesh Ranjan, senior journalist and internal security expert, and Bala Nagendran D, Akashvani correspondent. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on a mobile app, News on AIR. This program is also available on our YouTube channel, News on AIR Official. You may share your feedback about this program through email at airnsdtalks@gmail.com or WhatsApp on 9289094044.